heartbeat of the now and the then, where the story starts and never ends. Tune and lean and feel the groove. Every moment, a vibe you can't lose. It's for the culture, by the culture. Brilliantly's got the soul to show you. Breaking it down, lifting it higher. Feel the rhythm, spark the fire. Hear the whispers in the city's hum, echoes of stories where we're from. A beat, a step, a voice so clear, the pulse of us, it's all right here. We got soul, we got flavor. Every moment is a savior. Every experience is an overcome.
Well, hello to you, and you. Welcome in to another edition of Brainley's Virtual Tour Live. Glad to have all you here once again. Yes, indeed. Woo. Lord Jesus, a lot going on in the world today. Of course, some new motions have been filed. And wait till y'all see this. Wait till you see this document that's been added to the court. Amicus, Curiae, I think that's how you say it. With that being said, higher is weighing, low is available, but either way, we got to go on tour. Yes, indeed, we do. Let me take down this iconic intro here. You see that virtual tour background? Yes, you do. You hear that virtual tour music, rather? Yes, you do. And then there is me. Hey, everybody, welcome in. Glad to have all you here. As you guys know, we always reflect where the culture is, and there was some news that just broke, so I want to get that out the way very quickly, and then we're going to get on to making it do what it do with this, because, y'all, we got a lot to talk about here. Trying to make sure that this loads up for us here. Okay, they'll do it for me here. Give me a moment, y'all. Sorry. Okay, let me try that again. There we go. Okay, so here is the breaking news that just happened right here from TMZ. Right here, Nene Leakes is returning to Bravo right here. Production sources tell TMZ the Real Housewives of Atlanta alum will appear on Bravo's newly announced working title series, The Real Housewives Ultimate Road Trip, which Andy Cohen announced during BravoCon. While the series was announced, no cast members were named. Okay. Yes, indeed. Our sources say Nene, who departed ROA after season 12 in 2020, will not be a full-time cast member, but will have a noticeable presence when the show makes its way to Atlanta. We're told she will only be appearing during the Atlanta leg of the trip. So congratulations to the one, the only, the legend that she is, Nene Leakes. All right, congratulations to her for sure. All right, y'all, let's get to it here. So wanted to start this tour with this. Elon Musk AI chatbot Gronk is flooding Twitter with non-consensual AI nude photos. Okay, this came out 6 days ago. From the Jasmine brand, Elon Musk's social media platform Twitter is facing renewed scrutiny after a new analysis found its AI chatbot Gronk rapidly generate thousands of non-consensual undress images in a single day. According to third-party research reported by Bloomberg, the app has emerged as a leading hub for AI-altered images that digitally remove clothing from photos people voluntarily posted online. Voluntarily posted online, not involuntarily, right? Since late December, users have increasingly prompted Gronk to manipulate images shared on the platform, often without the subject's consent. During a 24-hour review of the images posted by the Gronk account, the chatbot produced roughly 6,700 images per hour that were classified as sexually suggestive or nudifying, said Genevieve O, a social media and deep fake research. By comparison, the next five largest websites hosting similar content average just 79 new AI generated undressing images per hour over the same period from January 5th to January 6th. Victims targeted by the deep fakes have reportedly taken to arguing directly with Gronk in comment sections, highlighting growing concerns about moderation, consent, and AI misuse on Twitter. And so this is why I said right here, Megan Thee Stallion was right about this, and that's why she dragged that said person who did the most on Twitter. So, with that being said, let's get to this. Now, I know what you guys are thinking, Bray, what is that word? Don't worry, I got you. We're about to look up that definition right now because I never heard this word before. And y'all know I'm about transparency with y'all. So here we go. Here. Let's all hear it together.
Amicus.
So amicus curiae is an impartial advisor, often voluntary to a court of law in a particular case. So this person who wrote an amicus curiae, y'all, this is deep. Okay, so here we go. Shout out to Document Tingz once again. Like, comment, share, and subscribe to him on every platform he has. He also has a YouTube channel. Okay, so here it is. Here, brief of amicus curiae, Roberta A. Kaplan in support of plaintiff's motion for injunctive relief. So these are the table authorities referencing different things relating to this amicus curiae. So here we go. Interest of amicus curiae. Amicus, Roberta A. Robbie Kaplan, is an accomplished litigator with a focus on constitutional and civil rights litigation, particularly on behalf of victims of sexual assault and defamation. She has developed substantial expertise on issues involving the dissemination of harmful content online and in the media and in First Amendment jurisprudence. I think that's how you say it, rather. Jurisprudence, among other relevant matters. Now, I want you to listen to this resume, okay? Because this is pretty big. Ms. Kaplan currently represents E. Jean Carroll in her defamation and sexual assault cases against President 47, which President 47 had to pay $82.7 million to E. Jean Carroll, okay? The court-appointed guardian of Wendy Williams in her lawsuit against A&E Networks, Lifetime, rather, for the exploitation of Ms. Williams' image in the documentary Where is Wendy Williams, victim one in the prosecutions against Jeffrey Epstein for sexual abuse and trafficking, and the Digital Center for Countering Digital Hate, CCDH, in litigation brought by Twitter Corp over CCDH's exposure of hate speech and disinformation on Twitter's platform. Yeah, she got some weight to her behind her resume, okay? Ms. Kaplan has also represented victims of violence from the Unite the Right rally in Charleston, Virginia. Students, teachers, and parents in challenging Florida's Don't Say Gay law. Amber Heard and her defamation claim against Johnny Depp, and Elizabeth Windsor in challenging the defense of marriage. Ms. Kaplan was a founder of the Time's Up Legal Defense Fund, which Time's Up was referencing the Me Too movement, which provides support to victims of workplace sexual harassment, as a longtime instructor at Columbia University School of Law. So let's get to it. Preliminary statements: like many states, Florida has made significant investments to combat harmful conduct, including harmful sexualized conduct that take place online and can reach millions of viewers at the press of a button. For more than 2 decades, Florida has prohibited cyber stalking, which covers a broad range of online harassment and disparagement. Florida Statute 784.048. More recently, Florida has spearheaded efforts to address the peculiar evil of altered sexual depictions, also known as sexual deepfakes. Why do you think I referenced the Elon Musk post, right, from the Jasmine brand? Yes, indeed. Florida Statute 836.13. Also see H Judiciary Com Bill Analysis HB 1161 120th Reg says Florida 2025. These commendable laws that we as society should encourage other states to follow, especially given the proliferation of harmful disinformation, misinformation, offensive conduct online that undermines the individual's sense of safety, privacy, and control over one's image and reputation, and undermines our broader commitment to common truth, decency, and respect for one another. In this case, plaintiff Megan P., known professionally as Megan Thee Stallion, invoked these laws to put a stop to defendants' harmful online activity, including defendants' promotion of a sexually explicit AI-generated deepfake video depicting plaintiff. A unanimous jury determined that defendants' actions violate Florida's anti-deepfake statute and also form part of a broader course of conduct that constitutes cyberstalking. Having obtained a judgment in her favor of monetary damages, plaintiff now seeks injunctive relief to prevent defendant from engaging in further acts of cyberstalking, including through the promotion of deep pornographic deep fake videos, and should be for photos as well. But let's keep going. Plaintiff requested relief in accordance with the laws duly passed by Florida to combat this sort of harm is fully consistent with the First Amendment to the United States Constitution and the values that it embodies. The United States Supreme Court has long permitted the regulation of conduct that serves no public purpose and operates only as a mechanism of harm, such as non-consensual pornography. Sexually explicit deepfakes, a modern technological twist on the old problem, are no more entitled to protection than are things like Revenge P or sexually explicit images of children, and courts have routinely held that statutes targeted to this new form of digital harm likewise pass for constitutional muster. Anti-cyberstalking statutes like the Florida statute, under which plaintiff specifically seeks injunctive relief here, also constitutionally permissible because they regulate conduct, not protected speech. As such, the Florida statute properly recognizes that the promotion of deepfake pornography can contribute to a course of conduct amounting to cyberstalking. Rather, defendants' actions are a textbook example of victim-specific electronic misconduct, not protected speech, which the anti-cyberstalking statute rightly and constitutionally prohibits. Damn. So basically, what this is saying for the opening of this is that deep fakes can be to the levels of Revenge P, and not to mentioning the laws that have passed in Florida is elevating the potential for Megan to get the defamation claim back on for Milagro Gramz. Damn. The power of utilizing information, ladies and gentlemen. The fact that plaintiff now seeks forward-looking injunctive relief to complement the damages she has already received and to prevent defendant from continuing to engage in harassment does not change the First Amendment analysis. The general presumption against prior restraint on speech is not at issue when, as here, the plaintiff seeks an injunction that is addressed to conduct whose merits have already been adjudicated and found to lack any free speech protection in the first place. More broadly, the point of Florida's anti-cyberstalking statute is to provide an injunctive remedy for victims, and courts have never identified a facial constitutional infirmity in the statute. To the contrary, enjoining the type of conduct defendant engaged in here is wholly in keeping with the law standard distinction between protected speech and speech as a vehicle for harmful illegal conduct. These types of injunctions are also critical for ensuring that victims like plaintiff who decide to come forward and prosecute their rights to attain justice rather than draconic victories, and those who that those who are found liable, like defendant, are fully incentivized to comply with the law going forward. Here we go. Argument number one: the First Amendment does not protect conduct that operates as a mechanism of harm, including sexual deepfakes. The free speech clause of the First Amendment protects a broad range of expressions and can serve as a defense even in state tort suits. See Hustler Magazine, Inc. versus Fraudwell. But that protection is not all-encompassing. The Supreme Court has long drawn a distinction between expression that serves the purposes of the First Amendment by contributing to public discourse, advancing ideas, or participating in democratic debate on the one hand, and expression or conduct that operates as a mechanism of harm and serves no societal purpose on the other. The First Amendment does not insulate behavior that uses communicative tools to injure, intimidate, or coerce another person. So when you think about this, this is going back to, remember how, Milagro said that she wasn't a damn journalist, this, that, and the third. Remember how she said that she was new media, this, that, and the third as well. The gag was, it was up to the jury to give a recommendation. It was up to the judge to decide it. So the judge really has not decided that yet. I know that can seem confusing based on the delusions of grandeur that Milagro Gramz has, but as it's saying here, the First Amendment does not insulate behavior that uses communicative tools to injure, intimidate, or coerce another person. The First Amendment does not insulate behavior that uses communicative tools to injure, intimidate, or coerce another person. So, Milagro did use communicative tools to injure and intimidate Megan Thee Stallion, right? Because she said, I'm not changing a thing and sue my ass. That was intimidation, right? And she promoted a deep fake video, an adult deep fake video at that, and that was used to injure, right? Now, you could say that, the coercing of, Megan Thee Stallion was through the taunting of Milagro Gramz, which that's true. So in that case, injure, intimidate, and coerce another person, ding, 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 there it is for Milagro Gramz, because she actually did those three things. Moving on. Consistent with these fundamental principles, the court has long permitted states to regulate conduct like defamation, Jerks versus Robert Welch Incorporated, and truth threats, Virginia versus Black. The court has likewise held that the First Amendment does not protect speech integral to criminal conduct where words serve as the operative instrument of the prohibited act. See Gaboni versus Empire Storage and ICE Co. Other well-recognized exceptions include fraud, extortion, and other forms of expression used to accomplish unlawful acts. See Illinois ex reg Madigan versus Telemarketing Associates Incorporated. Building on these general First Amendment limits, the court has developed a separate body of law addressing sexually explicit and privacy invasive depictions that cause direct and individualized harm. The most prominent example is child sexual exploitation materials, which states may ban entirely given the severe and lasting harm their creation and distribution inflicts. See New York versus Ferber. Although the court later struck down a federal prohibition on virtual child P and Ashcroft versus Free Speech Coalition, it did so because the banned material, which appeared to be CP, was produced by means other than using real children, such as youthful-looking adult actors, records no crime and creates no victims by its production, underscoring that Ferber still applies where real individuals are harmed. So basically, what they're saying is, how you can go to Sora AI, ChatGPT, Gemini, Quillbot, any one of these, right? And you can use youthful-looking adult actors, right? They are saying that records no crime and creates no victims by its production. Okay, so I don't get how that works, because that should be a fucking crime to be able to do that. You know what I mean? But hey, this is what I'm reading here as you guys are hearing it. But it's underscoring that in that case of New York versus Ferber, that it still applies where real individuals are harmed. So if somebody uses an actual child, right, and the image of that child to be able to make it do what it do with CP, then that still gets applied. Okay, so just want to break that up for y'all. The Supreme Court has also recognized that the First Amendment does not protect the use of speech used as a vehicle for harmful illegal conduct. In United States versus Williams, the court upheld a statute that prohibits the promotion of unlawful sexual images. Mm-hmm. 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 Back to this here, as it pulls up. Back to this here. Elon Musk's AI chatbot Grok is flooding Twitter with non-consensual AI nude photos. New report claims. Mm-hmm. Yes, indeed. There explained that such acts are categorically excluded from First Amendment protection because they function as conduct integral to the underlying harm. The court explained that the liability does not turn on whether the underlying image is real or virtual, but rather on the misuse of the words or images to facilitate abuse. Lower courts have reached the same conclusion. For example, in United States versus Tatum, the court credited evidence that the defendant used a deepfake generator to create new images of teen girls and an ex-girlfriend who was a minor. It treated those images as sexual exploitation materials supporting federal charges. That the images were fabricated did not diminish the harm. The same logic underlies Myron Revenge P statutes and civil remedies for non-consensual adult pornography. Courts across the country have recognized that such conduct falls well outside the protections of the First Amendment because it constitutes a direct invasion of personal autonomy, privacy, and dignity, not the well-protected expression of an idea. See State versus Van Buren. Disseminating sexually explicit images without consent has no connection to matters of public concern. Instead, involves the most private of matters. People versus Austin. Statute addressing non-consensual dissemination of private sexual images does not burden substantially more speech than necessary to advance its substantial governmental interests. Deepfake pornography has emerged as a modern form of non-consensual pornography, and a handful of states have led the charge in enacting statutes expressly addressed to the creation or distribution of such technologically altered sexual images, like prohibitions on child sexual exploitation materials and laws targeting the non-consensual dissemination of intimate images. Florida's deepfake statute, 836.13 addresses a form of sexualized impersonation that invades a victim's privacy and inflicts severe psychological or reputational harm. And if you guys remember in the trial, they talked about all the deals, right, that Megan lost out on. They also talked about the therapy that Megan had to go to. So there is the psychological and reputational harm there. The statute regulates conduct, specifically the willful creation or promotion of a sexually explicit image that falsely purports to depict another person when that conduct is used as a tool of abuse. Given the recency of such laws, only one appellate court has addressed a constitutional challenge to a deepfake statute to date. Its analysis recognizes that sexually explicit deepfakes are every bit as harmful as real sexually explicit images, and that AI cannot be used to evade the law. In Gramz versus State, the Maryland Court of Appeals upheld amendments to the state's child pornography statute that were enacted in response to the developing technology that allows pornographers to utilize computers to create images and videos in which the naked eye is unable to identify that the image is not of an actual child. The court noted that one aim of this legislation was a technology dubbed deepfakes, and held that the statute, which limited liability to images indistinguishable from an actual and identifiable child, was not overbroad because such imagery implicates the interests of an actual child and exposes that child to reputational and emotional harm. In other words, when AI generated imagery uses the likeness of a real identifiable person to depict sexual conduct, the resulting harm is analogous to established forms of non-consensual pornography rather than protected expression. So basically, what I am getting from that is when you are a full-grown adult and you can consent and everything is copacetic and there is boundaries for what the self-expression is, you're all good to go. But when it is a child that cannot consent and there is no boundaries and it is all willy-nilly in terms of what can be interpreted to the eye of the beholder, that's when it gets out of line. That's what I'm getting from that there. Other courts have reached the same conclusion about the harm that arises from the use of deep fake sexual imagery. In the One versus Nature Conservancy, the defendant created and posted sexually explicit deep fakes of his co-workers. Oh, good God. Wow. And the court recognized that conduct as inherently harmful and actionable under multiple tort theories. The court did not treat the deep fakes as expressive activity or speech, but rather as a form of personalized digital abuse that caused emotional or reputational harm. Modern scholarship reinforces this understanding. One scholar identifies sexual deepfakes as a type of sexual privacy invasion that should be treated and penalized as such, explained that the right to be free from such invasion is foundational to human dignity and serves as a cornerstone for sexual autonomy and consent. As another set of commentators put, like other forms of non-consensual pornography, deep fakes erode the trust that's necessary for social relationships and weaponize targets' speech against themselves. Mary Ann Franks and Ari Erza Waldeman, Sex, Lies, and Videotape Deep Fakes and Speech Delusions. And then right here, Daniel K. Crichton, Sexual Privacy, right there. This court has already recognized that plaintiff's allegations under 836.13 fall within the scope of the statute, ECF 36 at 18. After a trial, the jury found the defendant liable for the promotion of a altered sexual depiction in violation of 836.13 ECF 227 at 1. These rulings confirm that defendant's conduct fits squarely within the kind of targeted, privacy invasive abuse the statute was designed to reach. Number 2, cyberstalking and deepfake abuse fall outside the First Amendment's core protections. The question before the court now is whether it may enter a cyberstalking injunction based on the jury's findings. Nothing in the First Amendment forecloses that relief. Florida's cyberstalking statute targets repeated malicious electronic conduct, not expressive content. I'm going to read that 2 more times. Malicious electronic conduct, not expressive content. Malicious electronic conduct, not expressive content. And courts regularly uphold laws of this kind when the challenged behavior operates as harassment rather than speech. The jury's verdict that defendant promoted a sexually explicit deep fake depicted plaintiff establishes the sort of conduct the statute lawfully reaches. Florida's cyberstalking provision falls squarely on the conduct side of the First Amendment, speech versus conduct jurisprudence, and is constitutional under settled First Amendment principles. Section 784.048 D prohibits willful, malicious, and repeated electronic acts directed at a specific person that can cause substantial emotional stress. For the statute 784.048 1D. 2. In this respect, the cyberstalking statute functions no differently than traditional harassment or intimidation laws that have been long upheld as constitutional because they regulate behavior, not the ideas conveyed through that behavior. Federal courts have adopted the same understanding when analyzing the federal cyberstalking statute, 18 U.S.C. 226 1A 2. In United States versus Fleury, the 11th court rejected both facial and as-applied First Amendment challenges to 226 1A2, finding that the statute targets conduct performed with serious criminal intent and is not unconstitutionally overbroad because its legitimate sweep encompasses countless amounts of unprotected conduct. Florida's cyberstalking statute mirrors the federal statute in all material aspects. Both require 1, course of conduct, 2, directed at a specific person, 3, performed with the intent to harm, harass, intimidate, threaten, 4, that causes or would reasonably be expected to cause substantial emotional distress, because 226(1)(a)(2) is constitutional even when applied to conduct involving speech. 784.048 logically survives the same scrutiny. Deep fake sexual imagery used to humiliate or intimidate a real person reflects the same harm that Florida's cyber stalking and cyber harassment laws were intended to prevent. When a abuser weaponizes deep fake technology to target a specific individual, the abuser engages in the kind of emotional distress inflicting behavior that 784.048 has always addressed: malicious electronic conduct directed at a particular victim. Florida's legislative history confirms that deep fake abuse belongs within this framework. Before enacting 836.13, the legislature addressed similar image-based abuse primarily through its sexual cyber harassment statute, which prohibits the electronic dissemination of intimate images intended to cause substantial emotional distress. See Florida Statute 784.049. In the bill analysis for SB 1798, the legislation creating the deepfake statute, the legislature, explained that emerging technologies, including AI-generated sexual images, Elon Musk, Gronk, Twitter, looking at y'all, enabled offenders to evade existing cyber harassment, cyber stalking provisions as appropriations, bill analysis, and fiscal impact statement. That happened in Florida on April 21st, 2022. Legislators identified this technological gap and passed 836.13 to close it, adopting the same harm-based structure that defines Florida's cyberstalking regime. Both statutes focus on the misuse of electronic tools to inflict targeted abuse, not on the content of any underlying expression. In this way, 836.13 functions as a focused extension of Florida's cyberstalking protections, addressing a modern technique through which a cyberstalker can injure a victim. So they're basically saying you don't have to really be in person to stalk and harass and bully. They are also taking the virtual world and the ways that you can get to somebody virtually as cyber stalking, bullying, and harassment. Now, I'm sure that Milagro did not know any of this, but yet she was the one that said, $59,000 was a blessing. Little did she know there was a storm coming after the case. And for everybody else, we knew that the case wasn't over. Exhibit A. Yes, indeed. This same reasoning supports the court's authority to treat defendants' deep fake conduct as a part of the course of conduct under Florida's anti-stalking statute 784.048. The same cyber-stalking statute does not require each act within the course of conduct to violate the same statute or to constitute a separate criminal offense. Instead, it asks whether the defendant used electronic means to engage in a pattern of malicious behavior that caused substantial emotional distress and serve no legitimate purpose. Deep fake sexual impersonation naturally satisfies that inquiry. When an abuser disseminates or amplifies a sexually explicit synthetic image of a victim, the abuser enhances the coercive force of the harassment and magnifies its emotional impact. Florida's stalking framework does not hinge on whether the abuser uses words, images, or digital fabrication software. It hinges on whether the abuser uses electronic tools to harm a targeted individual. Defendant's conduct is a prime example of these harms. She liked a sexually explicit deepfake video purporting to depict plaintiff and, as the jury found, willfully promoted it to thousands of followers. Defendant's acknowledgement at trial that if I said to go on my likes and I posted, it would bring attention to plaintiff. In light of the legislature's stated intent and the structure of Florida's statutory scheme, that conduct is not an isolated act outside the stalking analysis. It is a core part of the malicious distress inflicting course of conduct that 784.048 authorizes courts to enjoin. Plaintiff's testimony that as a result of defendant's behavior, including promoting the deep fake, I genuinely did not care if I live or died. The cyberstalking statute empowers the courts to prevent ongoing harassment by considering all components of defendant's electronic abuse. To be sure, not all deepfakes outside the protections of the First Amendment, political or satirical deepfakes, for example, will often lie at the heart of protected expression. But the issue here is very different. Unlike the law struck down Coles versus Bonata, for example, which regulate political deepfakes criticizing elected officials, 784.048 does not burden public commentary at all. The content at issue here involves a sexually abusive deepfake targeted at a single individual. Florida's cyberstalking statute targets precisely that kind of victim-specific electronic misconduct, not protected speech. Okay. Number 3, the First Amendment does not prevent the court from issuing injunctive relief. So remember how I showed you guys that form that the judge, denied Megan's, injunctive relief for the defamation claim to get back on for those fees to be tacked onto the $59,000. It was denied because it was premature. There was somebody on Twitter under, Document Tingz that said, she got denied, and Boo was like, no, she got denied because it was premature. And the judge wanted Milagro Gramz to respond to it, right? So, yes, indeed. Now, we do know that if she did not respond to the defamation claim by, no, I think it was for the cyber harassment. She didn't respond by January 9th, there was automatically going to be a default. But Milagro did respond. Keep that in mind. Because right after this, there is a withdrawal motion that was filed. Wait till you see who. Okay. Let's see here. The First Amendment analysis is not altered by the fact that plaintiff seeks an injunction to put into defendant's campaign for harassment or face penalties going forward. First, courts, of course, may grant injunctive relief in circumstances like these, where the merits of speech have been fully adjudicated and found to be beyond the scope of anything possible, of any possible constitutional protection, rather. To be sure, prior restraints on speech bear a heavy presumption against their constitutional validity. Bantam Books Incorporated versus Sullivan and injunction directed to speech is a classic example of prior restraint on speech triggering First Amendment concerns. Chevadina, sorry about that if I butchered it, versus RK/FL Management Incorporated. But prior restraint analysis does not come into play where the First Amendment is not implicated as liability in the first place. An injunction that is narrowly tailored based upon a continuing course of repetitive speech and granted only after a final adjudication on the merits that the speech is unprotected does not constitute an unlawful prior restraint. Auburn Police Union versus Carpenter. Citing Pittsburgh Press Co. versus Pittsburgh on home rails. Here, in denying defendant's motion to dismiss the amended complaint, this court implicitly rejected defendant's arguments that the conduct in question promoting a pornographic deepfake video, depicting plaintiff and engaging in the other actions that formed the basis for the cyberstalking claim was protected by the First Amendment, ECF 36. Following trial, a jury then determined that defendant's actions fell squarely within the boundaries of conduct that is impermissible under Florida's anti-deepfake statute 836.13, and that the same course of conduct constituted intentional infliction of emotional distress, ECF 227. In reaching that verdict, the jury necessarily found that defendant engaged in conduct that was extreme and outrageous, undertaken with at least reckless disregard of the probability of causing severe emotional distress, and that in fact caused such distress, ECF 224, because defendant's continuing course of repetitive speech has been established and because there has been a final adjudication on the merits that the speech is unprotected, The narrowly tailored injunction that plaintiff now seeks does not implicate concerns about prior restraint. Auburn Police Union. Even beyond the particular findings of the jury, prior restraint principles do not prevent the court from exercising its authority to give meaning to plaintiff's judgment and stop further efforts at harassment. The Supreme Court has never held that all injunctions on speech are. Give me a moment, y'all. Okay, there we go. Okay, so I was right here. Let's see. I'm gonna go back to right here. In reaching that verdict, the jury necessarily found that defendant engaged in conduct that was extremely outrageous, undertaken with at least reckless disregard of the probability of causing severe emotional distress, and that in fact caused such distress. ECF 224. Because defendant's continuing course of repetitive speech has been established, and because there has been a final adjudication on the merits that the speech is unprotected, the narrowly tailored injunction that plaintiff now seeks does not implicate concerns about prior restraint. Auburn Police Union. Even beyond the particular findings of the jury, prior restraint principles do not prevent the court from exercising its authority to give meaning to plaintiff's judgment and stop further efforts at harassment. The Supreme Court has never held that all injunctions on speech are impermissible. Pittsburgh Press Co. In particular, four of the courts have recognized that there is a limited exception to the general rule prohibiting speech injunctions where the defamatory words are made in the furtherance of the commission of another intentional tort. So remember when Milagro Gramz say I'm going to go in the studio and make it do what it do because that's where I'm going to express myself, but anywhere else it's like ha ha ha. So wow, it is what it is. That doesn't mean you can't undercut, be nice, nasty, and shade saying something without really saying something, right? So that's basically what the court is. Well, that's what basically this person here is saying. We're almost done, yeah. We're on page 19 of 27. In her briefing on the motion to dismiss, defendant principally relied on Chavella for the proposition that the First Amendment prohibits such restraints on speech through the use of injunctive relief. ECF 30-18, by as noted above, Shimvanisa rather recognizes that this prohibition is not absolute. 113 so 3D at 1090, and the court's analysis of the record there, which led it to reverse the lower court's entry of a temporary injunction, illuminates why the injunctive relief plaintiff seeks falls within the exception to the rule. In Shevadina, the appellate court lifted the lower court's injunction on conduct that allegedly amounted to tortious inference with business relationships and defamation because the record failed to support an inference that Miss Shevadina's blogs were having a deleterious effect upon prospective tenants. The court further held that the injunction was overbroad because it improperly burdened Ms. Shevadina's speech more than necessary, attempted to enjoin future defamation, and failed to put Ms. Shevadina on notice as to what she may or may not be able to do under the injunction. The court reversed the injunction on conduct allegedly constituting stalking and trespass for similar reasons. The appellees failed to introduce evidence that specific blog posts were being used to communicate or to cause to be communicated words, images, or language directed at a specific person, causes substantial emotional distress to that person, and serving no legitimate purpose. Thus, injunctive relief was improper because the record below failed to establish that the conduct was being enjoined. What being enjoined was in furtherance of any of the underlying intentional torts. No such evidentiary deficiency exists here. Rather, a jury has already found that defendant's actions violate Florida's anti-deepfake statute, and that her promotion of the pornographic deepfake video depicting plaintiff along with other conduct constitutes cyber stalking. This final adjudication on the merits obviates prior restraint concerns altogether. Auburn Police Union, AF3D at now 3 as Noah, but even to the extent that the principal comes into the picture, the record establishes that the relief plaintiff now seeks is covered by the exception to the general rule articulated in Shaveda. Oh my God. 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 They are using every single thing that Milagro Gramz does not know to let her know, like, no, you did not win this. And child, when I tell you and show you and read to you the withdrawal motion that has been filed, child, this looks like it's signed, sealed, and delivered that Megan Thee Stallion is going to win it. To me, in my opinion. But just wait, we're almost there. We're on page 20 of 27, almost there. In fact, there can be no question that Florida's legislature intended for courts to enter injunctive relief in these circumstances. The deepfake statute provides that a aggravated person may initiate a civil action against a person who generates or promotes a pornographic deepfake in order to obtain proper relief, including injunctive relief. Florida statute 836.137A and Florida's anti-stalking statute expressly creates a cause of action for an injunction for protection against stalking, which shall include the offense of cyber stalking. Damn. They say whether you do it in reality or whether you do it virtually or in reality, you're stalking. Either way, that's basically what that's saying. Therefore, the statute 784.04851 and a separate statute, the legislature established procedures governing circumstances where an injunction for protection against stalking or cyber stalking has been violated. See for the statute 784.04871. In enacting these statutes, the legislature was cognizant of potential First Amendment concerns, but it determined that any such concerns did not stand as an obstacle to provide an effective redress for victims of such heinous conduct. For example, although the Florida Senate acknowledged that a complete ban of deepfake images will likely run afoul of constitutional protections under the First Amendment, it recognized that certain categories of speech, including defamation, fraud, true threats, and the imminent and likely incitement of violence, do not receive protections under the First Amendment. Let me read that 2 more times. It recognized that certain categories of speech, including defamation, fraud, true threats, and the imminent and likely incitement of violence, do not receive protections under the First Amendment. It recognized that certain categories of speech, including defamation, fraud, true threats, and the imminent and likely incitement of violence, do not receive protections under the First Amendment, and that some deep fakes will likely fall into one of those categories. I would say defamation and fraud. Now, when you're thinking of fraud, you're thinking probably of like Destiny Payne, what she did with, identity theft fraud, right? But fraud could be also frauding the public, false advertisement, right? That really wasn't Megan. So that was frauding the public and defaming her character, where now she seems like she has a reputation that's not really true, that causes her to lose on deals and then make her go to therapy. And then, of course, you have Mob Radio, the decrepit, dilapidated, and broken, cult that they are, allegedly, threatening, Megan fans and this, that, third, and so on, division, hatred, and strife. And I believe that Mob Radio could actually do this, the immediate and likely incitement of violence. I do believe that Mob Radio has the power to do that. That's my opinion. Okay? All right? Moving on. So all of that does not receive protections under the First Amendment. Impact statement to SB 1798. Also see United States versus Alvarez, 567 U.S. 709 717 2012. True threats, speech integral to criminal conduct, defamation, and obscenity are not protected by the First Amendment. Page 21 of 27. We're almost there, everybody. The careful drafting of these statutes explain why courts interpreting them have never identified a factual constitutional affirmity in their allowances for injunctions. Let me go back to that word because I want to make sure that I get it right. Amicus. Thank you so much, Google. Amicus is not aware of any of the judicial decisions concerning injunctive relief entered pursuant to Florida's anti-deepfake statute. The courts routinely grant injunctive relief under the cyberstalking statute at issue here. So the amicus, the person that is submitting this, which that person is Roberta A. Kaplan. She has no idea, right? She has no idea. She has no idea of any of the judicial decisions concerning injunctive relief entered pursuant to Florida's anti-deepfake statute, right? But courts routinely grant injunctive relief under the cyberstalking statute at issue here. See Rosley versus Karangi. Florida District Court Appeal 2022 course of conduct, including driving by petitioner's house and using a drone to spy on her, supports the issuance of an injunction. That is for this case right here, everybody. All of that is for that case right there. Toma versus O'Neill, Florida District Court Appeal 2015, conduct including mailing a flyer that identifies the victim by name and face, gives her residence address, and encourages people to approach her home, support injunction. Where courts have determined that injunctive relief is not warranted, they have typically done so because the evidence does not support a finding of stalking. See Wright versus Norris, Florida District Court Appeal 2021, cyberstalking injunction improper where emails and text messages were not addressed to the petitioner herself. Online posts were not directed at a specific person, and petitioner did not testify to the content of the text messages sent to her. Indeed, Section 704.048 itself recognizes the First Amendment rights of individuals by concluding that a course of conduct for purposes of the statute does not include protected speech. David versus Textor. Florida District Court Appeal 2016. Accordingly, Florida courts have declined to enter injunctions, whereas applied to the relevant conduct, the injunction will restrain protected speech. CEG ID injunction improper to restrain online postings that simply provide information regarding petitioner and the main lawsuits against him. Conversely, they have upheld injunctions on speech that falls beyond the boundaries of the First Amendment. CEG Toma 100A SO 3D at 1160. The flyer crosses the line in terms of First Amendment protection because the mailing of the flyer to the victim's home by itself was an attempt to force unwarranted speech upon her in the privacy of her home. Granting an injunction in this context is consistent with how the law remedies similarly egregious violations of decency. Revenge P, the non-consensual dissemination of another's intimate visual images, is a close cousin of the kind of sexually explicit deepfakes defended promoted here. Doe versus Constant. It harms also are similar. As with deepfakes, the impact of Revenge P can include public shame and humiliation, inability to find new romantic partners, mental health effects such as depression and anxiety, which Megan went to therapy for, so that falls under that. Job loss or problems securing new employment, deals were lost, and offline harassment and stalking. Ding 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 ding. Furthermore, once disseminated, it is challenging to completely move these images from the internet. Internal citation omitted. Those are precisely the kinds of serious harms to which plaintiff and others testified at trial. Plaintiff explained to jury that the result of defendant's as a result of defendant's actions, she did not feel like existing anymore, was tired of waking up and just wanted to die. Plaintiff's manager, a longtime friend and confidant who first showed her the deepfake, described plaintiff's immediate reaction after seeking the video on her tour bus. She cried, she just shut me out the room. She went to her room and just cried, didn't come out for, a few hours. This was on November 19, 2025. I'm guessing this is 24-hour time right here, 51:22 and 52:1. Plaintiff psychologist testified to the longer-term effects of defendant's conduct, including impacting plaintiff's familiar and other interpersonal relationships, negatively affected her desiring to work, and contributed to diagnosis of PTSD, post-traumatic stress disorder. Plaintiff's counsel summed up the harms in his closing statement. Once a deep fake is in the system, the lies it perpetrates, and it goes viral, you have ruined somebody's life. Given the severity of the harms it creates, courts regularly enter to prevent revenge P. Granting preliminary injunction and knowing that the federal anti-revenge P statute under which plaintiff seeks relief expressly contemplates the issuance of injunctive relief, SS versus Collins, July 31st, 2024, the court finds that the public interest would be served for issuance of a permanent injunction against defendant for the dissemination of intimate images and videos of plaintiff. So for this case right here, the court finds that the public interest would be served for issuance of a permanent injunction against defendant for the dissemination of intimate images and videos of plaintiff. Let me read that one more time. The court finds that the public interest would be served with the issuance of a permanent injunction against defendant for the dissemination of intimate images and videos of plaintiff. And Congress engaged in the careful, explicit creation of a statutory case of action, or cause of action rather, permitting injunctive relief to protect persons from this insidious form of harassment. The revenge P cases, like the cases arising in Florida's courts under the anti-stalking statute, reflect the unfortunate reality that injunctive relief is often a necessary remedy to ensure that victims of malicious and degrading conduct, like defendants, are not victimized. Yet courts can and often do provide substantial monetary damages to plaintiffs for defamation related towards damages that, while not strictly injunctive in nature, are clearly designed to dissuade further wrongdoing by those against whom they are directed. See Freeman versus Giuliani. Affirming jury verdict awarding $145,969,000. Let me read that number two more times. $145,969,000. $145,969,000 in compensatory and punitive damages for defamation and intentional infliction of emotional distress. So for Freeman Giuliani, that amount was the jury verdict for that case. Okay. Carroll versus 47. The jury's duly rendered damages awards totaling $83.3 million in compensatory and punitive damages, $83.3 million, $83.3 million in compensatory and punitive damages were reasonable in light of the extraordinary and egregious facts of the case, including President 47's continued defamation following a prior jury verdict as to the defamation on the same issue. To be sure, damages awards can have solitary forward-looking effects, but they are not always enough to deter future conduct. Here, for example, defendant has already characterized the jury's verdict against her as a win because it did not result in a multi-million-dollar settlement or fining. In other words, a price she was apparently willing to pay and may be willing to pay again to harm and degrade plaintiff. Damn. At trial, plaintiff recognized that as a public figure, her willingness to fight back against defendants' heinous actions could have positive effects beyond her own case. Maybe I'm going through all this because there's another woman that may be a victim and she sees me going through it, and she sees me coming out the other side. It may give her the courage or the strength to speak up and say, hey, this happened to me, and I'm not going to be scared of you. I'm not going to be intimidated by you. And Megan, with your foundation, there could be a whole division for cases like this. Just saying. There's plenty of lawyers that, they would love to be able to do bigger, stronger, and more impactful work. And I think your foundation, the Pete and Thomas Foundation, would be a great platform to make that happen. Just keeping it a buck. Let's see here. Entry of injunction. Plaintiff now requests would send the same sort of important and broad-reaching message to victims of sexualized online abuse. The First Amendment does not stand as an obstacle to this court making sure that the law and the jury's verdict are followed going forward. There we go. Wait. Come on now. There we go. In conclusion, I'm sorry. I gotta be extra, right? This case demonstrates how technological advances can amplify familiar forms of online harm, including harm based on sexually explicit images. Deepfake sexual imagery does not contribute to public debate. It reproduces patterns of intimidation and degradation that the law has long deemed unprotected. Florida's statutory framework acknowledges that this reality and the jury's findings confirm that defendant's conduct falls within it. Nothing in the First Amendment prevents a court from ensuring that the harm does not reoccur and that individuals need not endure the continued weaponization of digital tools against their dignity and safety. Amicus Curiae respectfully submits that the granting of the requested relief accords with the constitutional principles and the long-standing role of courts in protecting victims of targeted abuse. I just want to say to this person here, Roberta A. Kaplan, well done to you. You did your good shit on this one. Do you hear me? Very ironclad. That's not shaking for shit. And I don't think Milagro has it in her to continue trying to keep going around and around and around in her delusions of grandeur. I just don't think she has the energy in her to do it. And they use the interview with Gramz, Lonnie Cooper. Use a dummy, bitch. Anyway, I told you to follow my lead. Armand Wiggins got to be with that when he said Lonnie Gramz, Lonnie Cooper. Let's cry in financial blessings. Let's cry in coins. Let the tears rain down. Oh my God, okay. Here we go, y'all. Respectfully submitted, Roberta A. Kaplan, Pro Havice, D. Brandon Trice, Pro Havice, Christopher K. Canali, Pro Havice, Zara Nasser Jazari, Pro Havice, Kaplan Martin LLP, 1133 Avenue of the Americas, Suite 1500, 1500, New York, 10036, 212-316-9500. That's 212-316-9500. That's 212-316-9500. And all of these people here are Amicus Curiae, okay? R. Kaplan at kaplanmartin.com, B. Price at kaplanmartin.com, C. Connolly at kaplanmartin.com, and Z. Jasari at kaplan.com. And then Stephen F. Rosenthal, Florida Bar, number 0131458, Podhurst Orsec, PA 2525, Ponce de Leon Boulevard, Suite 700, Coral Coral Gables, Florida, 33134 305 358 2800. That's 305 358 2800. That's 305 358 2800. That's Rosenlaw at podhurst.com. Attorneys for Amicus, Roberta A. Kaplan. And then right here, this is the page here, local rule 7.1A3 certification on December 22nd, 2025. Amicus conferred via email with counsel for all parties in a good faith effort to resolve by agreement the issues to be raised in motion of Roberta A. Kaplan to appear as Amicus Curiae and file Amicus Curiae brief as required by this court's local rules. Counsel for the parties did not advise whether they consent to relief sought in the motion as of the date the motion was filed on December 23rd, 2025. The court has since granted leave to file the amicus brief DE 289, so no further conferral was necessary. Dated January 9th, 2026, Stephen F. Rosenthal. And then here's the certificate of service. I hereby certify that on January 9th, 2026, I electronically filed the foregoing with the clerk of the court using ECF rather. I also certify that the foregoing is being served this day on all counsel of record via transmission of notices of electronic filing generated by CMECF Stephen F. Rosenthal. And that is the final page there. 27 pages. Now, I will say Roberta A. Kaplan did her thing. And the reason why I said what I said of I don't think Milagro Gramz will have it in her to combat somebody that smooth, that articulate, and that much in her right damn mind is because of this right here, ladies and gentlemen. Remember why I said that withdrawal motion? Let's get to it now. Megan P. individual versus Milagro Elizabeth Cooper, individual defendant, also known as Lonnie Gramz, Lonnie Cooper. I swear Armand needs to make a merch line out of that. I swear to God he does. And you need to have that as a sound on your soundboard. I swear to God. So, y'all, here we go. Here we go. Motion to withdraw as attorney of record. Remember the two of the lawyers that withdraw from the case. Remember the other two that withdraw from the case. And whoop-Dee-Doo comes now undersigned counsel Jeremy McLemont. That's the one that everybody said was fine, but fine is in the eye of the beholder, y'all. Moving on. And respectfully moves this honorable court to enter its order allowing counsel to withdraw as counsel for defendant Milagro Cooper as for the grounds, therefore states the following. Number one, on June 5th, 2025, undersigned counsel filed his notice of appearance in this case, DKT 81. Number two, after a jury trial and final judgment was issued in this case, it was closed on December 2nd, 2025, DKT 227. Number three, as acknowledged in undersigned counsel's notice of appearance, undersigned counsel has advised Ms. Cooper of her right to appeal and filed by a timely notice of appeal on January 2nd, 2025. DKT 283. Number four, undersigned counsel is unable, because God is able. God is able. He won't fail. I love you, God. I really do. It was right there. I just had to go for it. Listen, is undersigned counsel is unable to continue representing Ms. Cooper in this matter and requests an order relieving Jeremy McLemont and the Ocelov law firm PA from all responsibility in this matter. Last note addressed from Ms. Cooper is blanked out, of course, because that is privacy, of course. That's the right thing to do and to be about and before Ms. Cooper. Undersigned counsel has confirmed with plaintiff's counsel who does not oppose the relief sought herein, wherefore undersigned respectfully requests this court to grant the motion to withdraw as attorney of record certificate of good faith conference. Prior to filing this motion, the undersigned conferred plaintiff's counsel in good faith on January 7th, 2026, and plaintiffs do not oppose the relief sought here and respectfully submit Jeremy McClement, Esquire, Acela Law Firm, PA, 33 Southwest 2nd Avenue, Suite 1100, Miami, Florida, 33130. Telephone number 786-420-3014. That's 786-420-3014. That's 786-420-3014. Jeremy Acela Law.com, Florida, bar number 1010776. Attorney for defendant, former attorney for defendant. Yes, indeed. Certificate of service on January 8th, 2026. I electronically filed this document with the clerk of court and serve a true and correct copy of all counsel record by Jeremy McClement, Esquire, Florida, bond number 1010776. So, she has no legal team. None whatsoever. So, I believe that Milagro should be getting ready to pay Miss Megan Thee Stallion. Yeah, you really should have just did other content, because in the words of Anonymous too.
Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because
one more time, Anonymous too.
Because here's the thing, a good streamer can find other content.
And that's what I thought. So now, yeah, we're gonna go with Document Tingz YouTube channel and give him some love. By the way, if you do not know who Document Tingz is, he is clutch in terms, again, everything that you need for what's happening in the court of pop culture when it comes to law. So, with that being said, I am going to showcase this video and give him some love, grace, and space here on the channel. Oh, already 27 likes. Awesome. Now 28. So with that being said, I'm going to turn off my camera now because we've done the whole show for over an hour. Yes, we have. And y'all can enjoy this video right here. Okay, here we go.
Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. Knock it to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. Knock it to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Oh, 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 yeah.
Hey guys, come on in, have a seat. Let's get into this court update. Now, without further ado, y'all already know about my copyright disclaimer in my QR code, direct link to the X page. Now,
before this,
let's get into this.
Before this, give me a moment, because I want to showcase the this one first. Hang on, give me a moment, y'all. Sorry. So here we go. Here, this one first, and then the other one. Okay, my bad. I didn't realize he did this one too. Okay, here we go. But of course, it would make sense. He did the the Amicus Curiae, but he also did this too. Okay, here we go.
Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. Knock it to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. Knock it to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Oh, 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 oh.
Hey guys, come on in, have a seat. Let's get into some court updates, okay? Y'all already know about my actual copyright disclaimer. Y'all already know about my QR code direct link to my X page. So let's get into this appeal saga because it has began, okay? Now, notice of appeal. Notice is hereby given that defendant Milagro Cooper hereby appeals to the United States Court of Appeals for the 11th Circuit from the December the 2nd of 2025 final judgment, finding defendant Milagro Cooper liable on counts 2 and 3 of plaintiff Megan Pete's second amended complaint filed on February the 10th of 2025. Now, with this appeal, in a prior video, which I will link at the end of this video, as some of y'all who do know or may not know, but we're going to reiterate, Megan Thee Stallion filed for an appeal first. Megan Thee Stallion did team up, okay, with Clairlock LLC, one of the top defamation firms in the world, to file an Amicus Curiae to attempt to reinstate count 1, which was defamation per se. So, as I mentioned before, this is now an appeal saga. Megan Thee Stallion is appealing to reinstate count 1, which is defamation per se. And now, as y'all see here, Milagro Elizabeth Cooper has filed an appeal on counts 2 and 3 based off the validity. Okay? Now, let's move on. Let me stop sharing. Okay, so let's move on to the next actual docket. All right, so let's get into this piece. This cause came before the court upon sua sponte review of the record on December the 17th of 2025. Plaintiff Megan Pete filed a motion for entry of permanent injunction against cyberstalking. To date, defendant Milagro Elizabeth Cooper has not filed a response to the motion nor requested an extension of time to respond, and the time to do so has passed. Accordingly, it is ordered in a judge that defendant Milagro Elizabeth Cooper has until January the 9th of 2026 to file a response to plaintiff Megan Pete's motion for entry of permanent injunction against cyberstalking, failing which the court will grant the motion by default. Now, for some of those or some of y'all who do not know, this was on January the 5th, okay? Now, today is January the 6th. So Jeremy McLamont, he has responded, okay? And let's take a look at that here. So this is the order just showing that this was granted. So this cause came before the court upon defendant Milagro Elizabeth Cooper's unopposed motion for extension of time to respond to plaintiff's motion to reinstate the jury's verdict, filed on January the 5th of 2026. Being fully advised, it is ordered and adjudged that defendant's motion is granted. So as of right now, the defendant has until January the 20th of 2026 to file her response to plaintiff Megan Pete's motion to reinstate the jury's verdict. Okay? Okay, so let's get into this particular court document, because this has had the internet in an uproar. And I just want to say that, in my opinion, this is not a win on either side, because this is normal. I mentioned this prior to the case actually starting. Both sides have the right to file for an appeal. Regardless of the outcome, they both have the right to file for an appeal. Okay? So this document right here is what had the internet in an uproar. And I want to read this, and I also want y'all to pause y'all screen and read this and digest this, okay? So this cause came before the court upon plaintiff Megan Pete's bill of cost, filed on January the 2nd of 2026. Plaintiff's pending motion to reinstate jury verdict and to amend final judgment or renewed motion for judgment as a matter of law, and defendant Milagro Elizabeth Cooper's notice of appeal call into question the validity and scope of the final judgment, entered on December the 2nd of 2025. The court will not act on plaintiff's bill of cost or any motion for fees until after an appeal is concluded. Accordingly, it is ordered in a judge that plaintiff Megan Pete's motion for bill of cost is denied as premature. Okay?
Yes, premature, everybody.
Pause your screen, read that, double read it. Okay, you have team plaintiff and you also have team defendant. They're both in an uproar online. And again, this is the beginning point of the appeal saga. Okay? What do you guys think? But let's go over the bullet points. Okay? First off, Megan Thee Stallion filed an appeal aiming to reinstate her defamation per se claim. Then Milagro Elizabeth Cooper filed her own appeal challenging the judgment. Because both of these appeals are now happening at the same time, the court decided to put a pause on deciding Megan's motion for taxable costs. They want to wait until all the appeals are resolved before making that decision. This delay is just a normal procedural step. The court is basically saying, let's not finalize any costs until we know the outcome of the appeals. Bottom line, we're in a holding pattern on the cost until the appellate court sorts everything out. And that's just part of the process when multiple appeals are involved. As I mentioned, Megan Thee Stallion has her appeal to reinstate the jury's verdict on defamation per se. And now you have Milagro Elizabeth Cooper filing for the validity in an appeal to her count 2 and count 3. If you like what you see here, like, share, and subscribe. I appreciate y'all. I love y'all. I couldn't do this without y'all. And as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, y'all have a good one.
Hey, everybody. Great job from the one Document Tingz there. This just came out 8 hours ago, okay? So there is a default order grant and a pro se response from Milagro Cooper, rather, okay? So here's the default order grant, okay? So here is this here, okay? Here we go. Once again, shout out to Document Tingz here. Megan Pete, plaintiff versus Milagro Elizabeth Cooper, order. This cause came before the court on a sub porne review of the record on December 29th, 2025. Clark Lock, rather, say that three times, rather. LLP filed a motion to appear as Amicus Curiae in support of plaintiff Megan Pete. Megan Pete's motion to reinstate jury verdict as to defamation claim, to amend final judgment or renew motion for judgment as a matter of law, ECF number 270 under local rule 7.1c. Each party opposing opposing a motion shall serve an opposing memorandum of law no later than 14 days after service of motion. Failure to do so may be deemed sufficient for granting the motion by default. To date, defendant Milagro Elizabeth Cooper has not filed an opposing memorandum of law, nor has she sought an extension of time to do so. So, right here, accordingly, it is ordered and adjudicated that Clark Locks LLP's motion ECF 270 is granted by default. It is ordered. It's done and ordered on Miami on this 13th day of January 2026. So this happened today. So Clark Lock LLP is, one that came in as an amicus curiae, which is the thing that I read from. Let me go back here. I'll make sure we get all this right on the record here, as we are live. Yes, indeed. Here from Roberta A. Kaplan. So that is the Amicus Curiae. So Cecilia approves that Amicus Curiae. Okay. Now, with that being said, let me get back to you all here. There we go. Let me get back to you all here. So with that being said, there is this that got filed today as well. So right here, this is the pro se response from Milagro Elizabeth Cooper here. So here we go, y'all. This was filed today. This just came out 8 hours ago. So I'm finding out live, like all of you are finding out live. So Megan Pete plaintiff versus Milagro Elizabeth Cooper defendant. Defendant Milagro Elizabeth Cooper. Now recognize she has no legal team, right, at all. So it's probably going to be broken, decrepit, and dilapidated as Milagro Elizabeth Cooper is as a whole person. So let's get to it. Defendant Milagro Elizabeth Cooper's pro se response and reply in opposition to plaintiff's motion for permanent injunction. Defendant Milagro Elizabeth Cooper appearing pro se, so she's appearing for herself, okay, respectfully submits this consolidated response and reply in opposition to plaintiff's motion for permanent injunction. Plaintiff seeks an extraordinary unconstitutional restraint on protected speech that's unsupported by the record, contrary to the jury's findings and inconsistent with controlling First Amendment law. Number one, introduction and procedural posture. Plaintiff's request for a permanent injunction arises after a jury trial in which the jury expressly determined that the defendant qualifies as a immediate defendant under law. So here's the thing, right? That was supposed to be a advisement, and even I think there was a motion that got filed when it came to the injunction, right, talking about that Milagro is not media. They said, and I quote, that usually juries do not decide something of that magnitude. It's usually on the judge. Okay, so Milagro's trying to get out of that, but no, boo boo. Kitty, no. Plaintiff's request for a permanent injunction arises after a jury trial in which the jury expressly determined that defendant qualifies as a mere defendant under Florida law. Plaintiff's defamation claim is dismissed as a matter of law for failure to comply with Florida's mandatory pre-suit notice requirement. Despite that dismissal, plaintiff now seeks to impose speech restrictions through alternative theories, effectively attempting to revive a defamation claim that no longer exists. No. The jury already found you as guilty for what you did. And Megan has the right to file an appeal to get that defamation claim back on. Okay? All right, moving on. Did I mention that Milagro Gramz has an SA lawsuit of her own with Mob Radio for Camp Mob? Yeah. If you want the documents to that, just type in Camp Mob lawsuit here on the channel. You'll get everything that you need to know. The court retained limited jurisdiction solely to consider plaintiff's injunction request, which does not authorize unconstitutional restraints on protected speech or relitigation of issues already resolved by the jury. Number two, plaintiff cannot satisfy the standard for a permanent injunction. A permanent injunction is an extraordinary remedy requiring proof of actual success on the merits or harm that the balance of equities favors the movement, and that the injunction will serve the public interest. Plaintiff cannot satisfy any of these elements. Number three, plaintiff cannot show the success on the merits. Now, it's interesting that we're talking about merits when this woman is negative $10,000 in the hole, lost her only source of income, the station head contract for $6,300, and she said, I'm not taking nothing back and sue my ass. Now we're talking about merits. Okay, child. The defamation claim has been dismissed. The jury expressly found that defendant functions as a immediate defendant. Once again, the jury was not supposed to make that. That was supposed to be the judge. That was an advisement, and the judge was supposed to take that advisement, but they're supposed to make the final ruling. So that is bullshit. Okay? This is a bunch of bullshit. This is lipstick on a pig. Basically, Milagro is trying to piss and tell us that it's raining. Okay, it's basically all that she's doing. Keyword trying rather to do. Plaintiffs attempt to re-litigate media stats by selectively signing pretrial remarks, ignores the evidentiary record. But in the pre-trial, though, they determined that you weren't media. So, child, you are so desperate to exist as anything but the liar that you are. Florida law applies as a matter of law once the jury made this factual determination. Said no one ever. Intentional infliction of emotional distress cannot support injunctive relief, and no malice intent exists. Plaintiff relies heavily on intentional infliction of emotional distress, but IIED cannot be used as an end run around the failed defamation claim. Trial evidence testimony demonstrated there was no malicious intent on defendant's part in regarding the alleged deepfake content. Yeah. But that was the thing that got you in court, sweetheart. So, if what you did got you in court, there was malicious intent behind it. Duh. Defendant was live on air when the video was first brought to her attention. Her surprise reflected genuine surprise and uncertainty. She explained in real time how viewers could access content through a public platform feature. The content remained accessible for approximately 15 minutes and was removed. The defendant openly opposed AI-generated content and stated that if the video was fake, plaintiffs pursue legal action against its creator. The defendant only learned that content was fabricated after plaintiff publicly stated so. The content was already circulating publicly, and there was no intent to deceive, harm, or target plaintiff. These facts do not satisfy the elements of IIED and cannot justify prior restraint. Plaintiff's IIED claim also fails to lack for specificity and existing content. Plaintiff's reliance on IIED is further deficient because plaintiff has failed to identify any specific post, statement, or publication that supports her IIED claim. At no point in her motion does plaintiff pinpoint a particular post, date, caption, video, or piece of content authorized by defendant that allegedly constitutes extreme or outrageous conduct. This omission is fatal. A claim for IIED, particularly one invoked to justify injunctive relief, requires identification of exact conduct alleged to be unlawful. Generalized references to online harassment or specific social media activity are legally insufficient, cannot support the extraordinary remedy of a permanent injunction. This failure is especially significant because the social media pages plaintiff broadly references no longer exist. Defendant's prior pages have been deleted and are accessible and cannot be reviewed or evaluated by this court. Child, they were able to get all the text messages that you deleted off of WhatsApp. Really? 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 They used your words about how you're not an official source for media. You still got your YouTube channel. You got Patreon. So the hell? You still got Twitch. The fuck? Moving on. Plaintiff does not identify any surviving content currently available to the public, nor does she explain how injunction can be fashioned when the allegedly offending speech has not been identified and reference platforms are defunct. An injunction cannot issue in a factual vacuum, and the court cannot restrain speech based on speculation or hypothetical future content untethered to an actual identifiable publication. She is really trying to get out of this, okay? It's not a factual vacuum that you were found guilty and you have to pay $59,000. That was factual, okay? And based on what you have done, there is a chance that you could do this again. That's a fact, okay? We don't have to have anything identifiable for us to believe that you could or could not do this again. The fact that you did it was more than enough. But moving on, plaintiff's attempt to proceed without identifying specific posts underscores that IIED theory is being used as an improper substitute for her dismissed defamation claim without a specific post. There is no basis for assessing intent, context, severity, or outrageousness, each of which is required to sustain an IIED claim. The absence of identified publication also precludes any finding of irreparable harm, as plaintiff has not shown that any existing content continues to cause injury or poses an imminent threat. Defendant's post-trial conduct undermines any claim of irreparable harm. Following trial, defendant voluntarily limited her public commentary. Well, there was that clip where you said, I'm going to go in the studio and, record, myself because that's the only way I can express myself because anywhere else is, So, yeah, you did realize that was part of post-trial conduct. Okay, moving on. She participated in post-trial and solely discussed her personal experience and reaction to the verdict. The defendant not direct threats, harassment, or commentary toward plaintiff, nor did she encourage others to do so. Like she had a fucking choice. Even after any gag order was lifted, the defendant chose not to discuss plaintiff on her show. Plaintiff cannot establish irreparable harm where speech has been affirmatively limited and no immediate injury exists. Response to Amicus, Curiae arguments, Amicus briefs filed in support of plaintiff, including the recent file by Roberta Kaplan, improperly attempt to reframe protected commentary as harassment advocacy as not media conduct. These arguments ignore the jury's finding and misstate Florida law. What's really interesting? If this is true, right, you would have bullet points of how they misstate Florida law. This is a blanketed statement that comes out to be shit. Like she is shit. Okay? All right. Moving on. Which determines media status by function, not viewpoint neutrality. Speculation about motive or bias cannot justify injunction or override First Amendment protections. Prior restraint and the public interest. The injunction sought will constitute a prior restraint, which is presumptively unconstitutional, particularly where the speaker is a media defendant comment on public proceedings. Once again, you are not a media defendant. The jury was supposed to give an advisement. Megan's team said that the judge was supposed to make that happen. So you are still not a media defendant. Okay. All right. Moving on. The public interest strongly favors free expression and press activity. The public also favors taking accountability, responsibility, and having integrity for what the fuck you do. Didn't you say that you would have to, take a class, or that you would take a class to understand the conduct of what new media would be? So why would you have to take a class for conduct of how be new media if you didn't do anything wrong? Let me say it 2 more times. Why would you have to take a class about how to conduct yourself as new media if you didn't do anything wrong, say you? How would you have to take a class to know the conduct of how be new media if you didn't do nothing wrong, per se you? Conclusion. Plaintiff has not met the heavy burden required for a permanent injunction. The request disregard the jury's findings. Once again, the jury was supposed to advise that media defendant thing, and the judge is supposed to make that final decision. Attempts to revive a bar claim. No, she's got the right to file an appeal just like you are filing this pro se to, combat Megan trying to do a permanent injunction on you. In the words of Lamar Wiggins, use a dummy, bitch, and seeks to restrict constitutionally protected speech. Plaintiff's motion for permanent injunction should be denied in its entirety. Certificate of service. Lord. I hereby certify that on January 9th, 2026, I served the foregoing response or reply in opposition to plaintiff's motion for permanent injunction by disposing a true correct copy in the United States mail, postage prepaid, and addressed to the clerk of court and all counsel for record. Alejandro Brito, Florida, bar number 098442. Jeline Garcia, Florida, bar 0058632. Berto, Berto, PLLC.com. J. Garcia, Berto, PLLC.com. Berto, PLLC, 2121 Juan de Leon Boulevard, Suite 650, Miami, Florida, 33134 305-614. 305-614-4071, 305-614-4071, 305-614-4071. And then, of course, Mari F. Henderson, Pro Hafweis, Marion Haprin, Pro Hafweis, Mari Henderson, Quentin Emmanuel, Marie Haprin, QuentinEmmanuel.com, Quentin Emmanuel at Quart Sullivan LLP, 865 South Figueroa Street, 10th floor, Los Angeles, California, rather 90017 213-443-3000. 213-443-3000. That's 213-443-3000. So I'm assuming that this person here, these two people here are for, let me make sure I get this right. I think those two people are for Megan, Pete, and then these people here, I'm assuming, are for Milagro Elizabeth Cooper. Ciao. Yeah. Okay. We'll see. Hey, Linnell, still good to see you, my friend. Good to see you. I'm going to turn off my camera again because we've done the whole show once again for over an hour. Yes, we have. All right, y'all. I'm going to show off Document Tingz video now for the pro se injunction relief here. Okay, so here we go. Again, like I said, like, comment, share, subscribe to Document Tingz on all his platforms. He is amazing. He's a legend. He is a king. Let's go.
Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Oh, oh, oh.
Hey guys, come on in, have a seat. Let's get into this court update. Now, without further ado, y'all already know about my copyright disclaimer in my QR code, direct link to the X page. Now, let's get into this newly filed update just as of today. So Milagro Elizabeth Cooper is appearing as pro se in reply in opposition to plaintiff's motion for a permanent injunction. And then right after this, I will go over the other court document in which Judge Cecilia Altanaga has granted Clearlock LLP's motion to appear as Amicus Curiae because there was no opposition. There was no response. So I'm going to get into those two documents right now. So let's get started, y'all. Grab your seats, grab your drinks, grab your snacks, and let's get right into this. Okay, so defendant Milagro Elizabeth Cooper's pro se response in reply in opposition to plaintiff's motion for permanent injunction. Defendant Milagro Elizabeth Cooper, appearing pro se, respectfully submits this consolidated response in reply in opposition to plaintiff's motion for permanent injunction. Plaintiff seeks an extraordinary and unconstitutional restraint on protected speech that is unsupported by the record, contrary to the jury's findings and inconsistent with controlling First Amendment law. Now, this is number one, which is introduction in procedural posture. Plaintiff's request for a permanent injunction arises after a jury trial in which the jury expressly determined that defendant qualifies as a media defendant under Florida law. Plaintiff's defamation claim was dismissed as a matter of law for failure to comply with Florida's mandatory pre-suit notice requirement. Despite that dismissal, plaintiff now seeks to impose speech restrictions through alternative theories, effectively attempting to revive a defamation claim that no longer exists. The court retained limited jurisdiction solely to consider plaintiff's injunction request, which does not authorize unconstitutional restraints on protected speech or re-litigation of issues already resolved by the jury. 2, plaintiff cannot satisfy the standard for a permanent injunction. A permanent injunction is an extraordinary remedy requiring proof of actual success on the merits, irreparable harm, that the balance of equities favors the movement and that the injunction would serve the public's interest. Plaintiff cannot satisfy any of these elements. 3, plaintiff cannot show success on the merits. The defamation claim has been dismissed, and the jury expressly found that defendant functions as a media defendant. Plaintiff's attempt to re-litigate media status by selectively citing pretrial remarks ignores the evidentiary record. Florida law applies as a matter of law once the jury made its factual determination. 4, intentional infliction of emotional distress cannot support injunction relief, and no malicious intent exists. Plaintiff relies heavily on intentional infliction of emotional distress, but IIED cannot be used as an end run around a failed defamation claim. Trial evidence and testimony demonstrated that there was no malicious intent on defendant's part regarding the alleged deep fake content. Defendant was live on air when the video was first brought to her attention. Her reaction reflected genuine surprise and uncertainty. Okay, so we're going to pause right here. Okay? We're going to pause right there because,
Peter Van here. You know, I thought growing up would be the worst, but then I found a way to hack adulthood. It's called AAA. With AAA, it's all about the perks, just like being a kid, except with better snacks and no bedtime. Yes, it pays to be a member.
Taxes was so taxing.
Now taxes is so free. Terrible tax, free edition only. Roughly 37% of filings qualify. Simple form 1040 returns only.
By the way, this is fire TurboTax, I have to say.
And get the most money back. Guaranteed.
Let's go here, okay? Just briefly, all right? So as y'all can see here, this was what was submitted to the courts on January the 17th of 2025, okay? First impression, as y'all can see here. Now, this is from my X page. If you want to get to this document, QR code right there at the top left-hand corner, and you can scroll all the way down. When you start seeing station head, and I'll show y'all just a second, when you start seeing the station head logos, then it's videos prior to actual trial, which was November the 17th of 2025. All right, so let's get right on into this. This is what she's claiming. Y'all see, pause your screen and read. Now, this is what she submitted to the courts. Now, in my opinion, at the time that this came out, I said, well, wait a minute, something is missing, because it was way more said in this video. Now, this is protected by copyright when it comes down to fair use. This is protected. Okay, so y'all listen to this.
Oh, God.
Fair use, everybody.
Do you think this will be AI? This has got to be AI. Because I know this bitch is not this dumb. And who would have been recording?
No, just keep.
But I don't know. It don't look fugazi.
Okay, y'all hear that?
I'm under no. Let me tell you something. I'm 80 steps ahead of Rock Nation. I'll never post that on my motherfucking page. But I'll put it on my motherfucking Discord though.
Y'all hear that? Did y'all hear that? Let's go back to this. There was way more said than what was submitted to the courts, as y'all can see here. Okay. Let's even go a step further. Now, let me take this off of the screen real quick. And let's go a step further because this was still in the exact same.
You know what?
Y'all can hear. Exact same video.
I'm not even going to do that. We have multiple mob PIs. I'm going to let Nigga Girl post it. Because y'all not about to put my motherfucking name on that shit.
Okay, now let's go to the end of the video. And this is what Megan Thee Stallion's legal team deemed as her promoting the deepfake video.
Watch how this post jump. This nigga had this video up for an hour. He got 4.8 thousand views. I just liked it and I tweeted. Go to my likes. Watch how this whole jump up.
Did y'all hear that? Okay, so let's continue. All right, so let's get back to it. So she explained in real time how viewers could access content through a public platform feature. Content remained accessible for approximately 15 minutes and was removed. Defendant openly opposed AI-generated content and stated that if the video was fake, plaintiff should pursue legal action against its creator. Now, there is also a video clip from the head of her saying that as well. However, what I just played y'all, all of that was said in the exact same video. So let's continue. Defendant only learned the content was fabricated after plaintiff publicly stated so. The content was already circulating publicly, and there was no intent to deceive, harm, or target plaintiff. These facts do not satisfy the elements of IIED and cannot justify a prior restraint. Plaintiff's IIED claim also fails for lack of specificity in existing content. Plaintiff reliance on IIED is further deficient because plaintiff has failed to identify any specific post, statement, or publication that allegedly supports her IIED claim. At no point in her motion does plaintiff pinpoint a particular post, date, caption, video, or piece of content authored by a defendant that allegedly constitutes extreme or outrageous conduct. This omission is fatal. A claim for IIED, particularly one invoked to justify injunctive relief, requires identification of the exact conduct alleged to be unlawful. Generalized references to online harassment or unspecified social media activity are legally insufficient and cannot support the extraordinary remedy of a permanent injunction. This failure is especially significant here because the social media pages plaintiff broadly references no longer exists. Defendant prior pages have been deleted or inaccessible and cannot be reviewed or evaluated by the court. Now, I want to take a pause here because as this trial is going on, and a lot of us are aware, right? There have been pages that have been taken down, as in banned. And that's what we know. Some of us that know that has been around and has been watching, right? Let's continue. Plaintiff does not identify any surviving content currently available to the public, nor does she explain how an injunction could be fashioned when the allegedly offending speech has not been identified in the reference platforms or defunct. Now, let's take a pause again. As y'all just seen on my X page, some of these audio clips are still available, right? Things that you delete off of the internet is not deleted. Someone has screenshotted, someone has clipped, and someone has access and has posted it on their personal pages. or in a group setting. So even though it's deleted, it's not truly deleted off of the internet. So let's just make that very clear. Now, this is my opinion alone. All right, let's continue. An injunction cannot issue in a factual vacuum, and the court cannot restrain speech based on speculation or hypothetical future conduct untethered to an actual identifiable publication. Plaintiff's attempt to proceed without identifying a specific post underscores that the IIED theory is being used as an improper substitute for her dismissed defamation claim. Without a specific post, there is no basis for asserting intent, content, severity, or outrageousness, each of which is required to sustain an IIED claim. The absence of an identified publication also precludes any finding of irreparable harm, as plaintiff has not shown that any existing content continues to cause injury or pose an immediate threat. And then this is number 5. Defendant's post-trial conduct undermines any claim of irreparable harm. Following trial, defendant voluntarily limited her public commentary. She participated in post-trial interviews solely to discuss her personal experience in reaction to the verdict. Defendant did not direct threats, harassment, or commentary towards plaintiff, nor did she encourage others to do so. Even after any gag order was lifted, defendant chose not to discuss plaintiff on her show. Plaintiff cannot establish irreparable harm where speech has been affirmatively limited and no immediate injury exists. Again, there are things that we all witnessed on both sides. Let's talk about both sides, on the defendant side and also the plaintiff sides, right? We all saw the press once trial was commenced, right? And then we all saw once everything was concluded. So as the days progressed, we saw, the press from them entering the court and exiting the court. And then as the final judgment came down, we all saw that as well. So y'all can go back, watch videos. You can go back and look at the actual court documents. It is available. All right, so let's get into this one. This is number 6. Response to Amicus Curiae arguments. Amicus briefs filed in support of plaintiff, including the recent filing by Roberta Kaplan, improperly attempt to reframe protected commentary as harassment and advocacy as non-media conduct. These arguments ignore the jury's findings in misstate Florida law, which determines media status by function, not viewpoint neutrally. Speculation about motive or bias cannot justify an injunction or override First Amendment protections.
Hey man, can you share your number 1 tip for business success?
Switch to Monday CRM.
Oh, awesome. Thanks.
Hold up.
Okay, y'all see that? Number 7, prior restraint in the public interest. The injunction sought would constitute a prior restraint, which is presumably unconstitutional, particularly where the speaker is a media defendant commenting on public proceedings. The public interest strongly favors protecting free expression and press activity. And then number 8, plaintiff has not met the heavy burden required for a permanent injunction. The request disregards the jury's findings, attempts to revive a barred claim, and seeks to restrict constitutionally protected speech. Plaintiff's motion for permanent injunction should be denied in its entirety. And with this being said, I think we need to go back to the actual jury verdict. I think if we go back to the actual jury's verdict, then that will allow us to have some type of sense of what happened and what was said, because there are a lot of things that has been misconstrued. And so for me, I think it is time for us to go all the way back down to memory lane. Now, this was in November. Okay, so we're going to go back down to November, and we're going to look at the jury's verdict.
I want to pause it for just a brief second, y'all, because I want to bring something up to y'all attention, if you don't mind, because I think people are being very delusional. Look at this right here. Right here. The court retains jurisdiction to entertain the request for injunctive relief in count 4 of the second amended complaint, ECF number 37. Let me come on camera and say that 2 more times for y'all real quick here. Okay, because Milagro is thinking that this is just coming out the blue. It's like, no, sweetheart, this is a part of the game. The court retains jurisdiction to entertain the request for injunctive relief found in count 4 of the second amended complaint, ECF number 37. The court retains jurisdiction to entertain the request for injunctive relief found in count 4 of the second amended complaint, ECF number 37. The court retains jurisdiction to entertain the request for injunctive relief found in count 4 of the second amended complaint, ECF number 37. Okay? All right. Back off camera. Back to Document Tingz here. Here we go.
Okay. So let me get that, y'all. 1 second. All right, so let's get right on into, I'm sorry about that, but let's get right on into, this was what the jury said. Now, this is the jury verdict form. Okay, now this is on count 1, defamation per se. Y'all can see right here. This is what the jury, when they officially said this, before this claim was actually taken out. But this is what the jury said. Now let's read. Question 1. Do you find by a preponderance of the evidence that Ms. Cooper is liable to Ms. Pete for defamation per se by accusing Ms. Pete of perjury, a felony, by lying under oath in a criminal trial when she asserted that 1, Ms. Pete was a non-credible witness, 2, I could go down the list of all the different SHIT that was not true, and 3, as was Megan Thee Stallion caught trying to deceive the courts again. This is originally what the jury said. They said yes, as y'all can see. If your answer to question 1 is yes, continue to question 2. Okay, so question 2. Do you find by a preponderance of the evidence that Ms. Cooper defamatory statements caused Ms. Pete actual damages? They said yes. Regardless of your answer to question 2, continue to question 3. During the time period when the statements were made, do you find by preponderance of the evidence that Ms. Cooper provided disinterested and neutral commentary rather than advocacy for a particular client or personal interest? Now, they said no. Okay, let's go to question 4. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper regularly disseminated news or information to the public rather than making an isolated or one-time publication? They said yes. Question 5. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper impartially disseminated information rather than acting primarily to promote her own business, product, or services? They said no. Then question 6. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper operated for the purpose of informing the public about matters of public concern?
Hey, one person, welcome in, glad to have you
here. They said yes. Okay, number 7. During the time period when the statements were made. Now, we're going to skip over this because it's like a repetitive thing. We're just going to go down to the actual question. That Ms. Cooper functioned in a similar manner to traditional news media, such as newspaper, magazines, television, radio, or their online equivalents. They said yes. And in question 8, Cooper should be treated as a media defendant with regard to the statements made in this case. They said yes. So that is count 1, which is defamation per se. So when it came down to the actual defamatory part, as you see here, they said yes. But down here, as we see, media defendant, they said yes. So in my opinion, by reading this, I would think, in my opinion, that this is a technicality where, hey, we are labeling her as a media defendant, which then removes this defamation per se claim, because as someone who is a quote unquote media defendant, you will have to give them a pre-suit notice. But as we see here, this is the original jury verdict when they said yes to her defaming Megan Thee Stallion. Okay. And then that's when we have this court document here. So let me take this off of the screen really quickly. And we're going to get into the actual final judgment. Just to be transparent on everything, okay? So here goes the final judgment. So right here, the jury also rendered its verdict as to defendant's media defendant status, finding that defendant should be treated as a media defendant regarding this statement at issue as a condition precedent to the defamation suit. Section 770.01 Florida statutes requires a plaintiff to serve a media defendant with a written notice specifying the alleged false or defamatory statements at least 5 days before filing a complaint, as y'all can see there. And so this is why defamation was omitted. And as y'all can see there, $59,000 in damages, as y'all can see there. So just to briefly go over that piece, okay? Now, let's get into this Amicus Curiae, okay? So when it comes down to the Amicus Curiae, by default, it was approved. Now, why was it approved? It was approved because there was no opposition filed. Okay, so y'all give me 1 second. Let me get this pulled up. All right, got it. Okay, so let's go over this order. This cause came before the court on a sua sponte review of the record. On December the 29th of 2025, Clairlock LLP filed a motion to appear as amicus curiae in support of plaintiff. Megan Pete's motion to reinstate jury verdict as to defamation claim and to amend final judgment or a renewed motion for judgment as a matter of law. You can refer back to docket 270. Under local rule 7.1c, each party opposing a motion shall serve an opposing memorandum of law no later than 14 days after service of the motion. Failure to do so may be deemed sufficient because for granting the motion by default, which as y'all can see here, it has been ordered and adjudged and granted by default because there was no memorandum of the opposing of this order. All right. And that is that. Now, I do have the Amicus Curiae. It is 27 pages. I may do a separate video reading over that, but until then, I would like to thank y'all for joining and going over these court documents with me. Like, share, and subscribe. I appreciate all of you. I cannot do this without you guys. So I love y'all so much. Now, as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, I will see y'all on the next video. Y'all have a good one.
Shout out to the one, the only, the legend that is Document Tingz for sure. Want to come back on camera here. I wanted to give him the floor to read all of that, even though I already read it for you all. Here is his YouTube channel here. So just wanted to just showcase that to you all. Yes, indeed. There we go. But yeah, I wanted to bring up that and shout out to that person on Twitter who said that the court can and can entertain an injunction. of the defamation claim. So, like, the court is allowing it. So Milagro doesn't really have anything to stand on, child. I wanted to bring these two tweets up here. Shout out to Patrice Davis, Megan Mai. So in other words, she doesn't want to lose Megan as someone she can bully without legal actions being taken against her. How slow is this woman? Really, there's nothing unconstitutional about it. You have harassed and bullied for years. Is making it a permanent decision that you will no longer have the privilege to do that, which is her complete right to do. This just goes to show that Megan is her only source to make a living, and that she's completely unnaturally obsessed with her. Bitch needs to be put in a straitjacket and put in a padded room with top security, because ain't no way you going this hard just to get the chance to continue harassing someone you don't even know or who knows you. And then schizophrenia, Christopher Robin. We love Christopher Robin over here, but I understand her point. And then Zen the Menace. I love that name. What a dumbass Milagro is. Well, what a dumbass Milagro is. Who's advising this hoe? If she want to stand 10 toes down on what the jury said, she better stand all the way in it. The jury found her liable for defamation. The jury found her liable for IIED. The jury held her accountable for pushing that AI deepfake on. The only reason the defamation count was tossed was on the technicality by the judge because she didn't do it. So if we're using her own logic, the jury said I'm me. And then she also needs to accept the jury said that she defamed Megan, caused intentional harm. You can't cherry pick justice. You were found liable, and now you're filing pro se, just like you're a little bit pope. The court said you did that shit. Shut up and take your L. And there was another person that did this pro se against a very famous celebrity, and he lost. So that should tell you everything that you need to know, that Milagro Gramz is the female version of AL, but that's neither here nor there. Y'all, that's it for me. That's all I got for y'all. Thank you so much for being here. With that being said, it's time for the best outro on YouTube. Know what you do and do what you know. Never say you want more special, because you will always want a blessing and trust. You may not be where you want to be, but at the end of it, you'll be where you need to be. Do what you've been chosen to do. Why it's one thing to call yourself, is another to be chosen. One love, much love, all love. I spend time with you. You spend time with me. Hopefully, I spend time together. Rise great together. And always remember, we're doing radio, television, YouTube, living your best life, or just reporting the facts as they are. The court retains jurisdiction to entertain the request for injunctive relief found in count 4 of the second amended complaint, ECF number 37. Make sure the replay is not just for if you watch it, not just for if you listen to it, but for you want to experience it again, rather. I love you, I value, I appreciate you all. Always remember, receive love, you gotta give it, receive love, you gotta give it, or receive love, you gotta give it, wherever obstacles you overcome, where success you have achieved upon this particular day. I'm extremely proud of you, but no one else is proud. Be proud of your damn self. And finally, y'all, listen. Whatever is going to happen with this is what is going to happen. But I do believe this is a very mental lesson for the rest of us, and a very hard-fought lesson for Milagro of, if you do what you're supposed to do, you will never have to worry about hell raining down on you. If you do what you're supposed to do, you will always be walking in a heaven-like atmosphere. Okay. All right. Commercial break and fireworks coming your way for the day that was, for the day that's coming, for the blessings on the way for you, me, all of us, as a society, as people, as culture. I feel the love and send it right back to you. By everybody. By the way, it does say right there that plaintiff shall recover from defendant a total $59,000 in damages. So, found guilty for the ORN, right? IIED, and got to pay $59,000. Negative $10,000 in the hole, and lost her only source of income. The station had contract for $6,300 a month, and she said, I ain't taking nothing back and sue my ass, and lost. But she knew media said no one ever. Good night.
I thought I should tell you, they've been talking about you. Yeah, they've been talking about you. They've been talking about the fact that they've done everything they could to stop you, and everything they could to block you, but you still win. They've been talking about the fact that they have undermined your success, and they have tried to sabotage your seasons, but you keep winning. They've been talking about the fact that even though they don't like each other, they get together to try to kill you, but you keep winning. They've been talking about the fact that you were voted least likely to succeed, but like cream, you keep rising to the top. They've been talking about how they tried to burn your world down, but like the phoenix, you rose from the ashes. They've been talking about you. And you know what they say? Oh, she's just lucky. He's just lucky. But no, you ain't lucky. You're anointed. You got something on you. You got favor on you. You got power on you. You were born to win. Now they can call it luck, but it's grace. They can call it luck, but it's favor. But whatever they call it, it doesn't matter, because you know what God calls you? Do you know what God calls you? A winner. I thought I should tell you they've been talking about you. Yeah, they've been talking about you. They've been talking about the fact that they've done everything they could to stop you and everything they could to block you, but you still win. They've been talking about the fact that they have undermined your success and they have tried to sabotage your seasons, but you keep winning. They've been talking about the fact that even though they don't like each other, they get together to try to kill you, but you keep winning. They've been talking about the fact that you were voted least likely to succeed, but like cream, you keep rising to the top. They've been talking about how they tried to burn your world down, but like the phoenix, you rose from the ashes. They've been talking about you. And you know what they say? Oh, she's just lucky. He's just lucky. But no, you ain't lucky. You're anointed. You got something on you. You got favor on you. You got power on you. You were born to win. Now they can call it luck, but it's grace. They can call it luck, but it's favor. But whatever they call it, it doesn't matter, because you know what God calls you? Do you know what God calls you? A winner. I thought I should tell you they've been talking about you. Yeah, they've been talking about you. They've been talking about the fact that they've done everything they could to stop you and everything they could to block you, but you still win. They've been talking about the fact that they have undermined your success and they have tried to sabotage your seasons, but you keep winning. They've been talking about the fact that even though they don't like each other, they get together to try to kill you, but you keep winning. They've been talking about the fact that you were voted least likely to succeed, but like cream, you keep rising to the top. They've been talking about how they tried to burn your world down, but like the phoenix, you rose from the ashes. They've been talking about you. And you know what they say? Oh, she's just lucky. He's just lucky. But no, you ain't lucky. You're anointed. You got something on you. You got favor on you. You got power on you. You were born to win. Now they can call it luck, but it's grace. They can call it luck, but it's favor. But whatever they call it, it doesn't matter, because you know what God calls you? Do you know what God calls you? A winner.
Good evening. My name is Mark Woodbury. I'm the chairman and CEO of Universal Destinations and Experiences. Well, we're finally here. Tomorrow we begin a new chapter at Universal Orlando Resort as we open Epic Universe. We built this place for you. I want to thank you, our fans, for your love of our stories, characters, and immersive experiences that inspired this incredible place. Epic Universe represents over 8 years of meticulous planning, immense creativity, and innovation, combined with unmatched craftsmanship and operational excellence on the part of thousands of people who have brought to life the stories and characters that live beyond each of Epic's portals. But it represents so much more. Your love of Universal and the deep connections we've shared together here in Orlando over the past 30 years inspired us to dream bigger, and to push the boundaries to create something extraordinary for you and for generations of fans and families to come. And tomorrow, as we open Epic Universe, I can't wait for you to experience this place for yourself. Now it's your turn to step inside, to lose yourself, and to share this place with the ones you love most. As we open this park, we hope your world becomes a little more epic. Tomorrow, Epic Universe becomes yours.
Are video games getting too expensive? This episode, we want to find some common ground because the CEOs want to raise the price even more.
Not with these broken-ass games.
$5 million. That's how much San Andreas costs to make. Is it their fault for selling or our fault for buying?
Corporations claim all this stuff. Devs say otherwise.
Sports gamers, cozy gamers, whatever you call the people who play Power Wash Simulator.
I think it stinks a little bit more because I'm spending my actual money and my mom is not. Imagine they get rid of all movie theaters and then charge you the same price to watch the same movie at home.
That's like every streaming service. It doesn't have to be the longest of games, but am I having fun with it? This is Lex. I'm Ronell. Let's get right into it.
Prepare for a journey beyond imagination, beyond belief, beyond anything you've experienced before. Universal Epic Universe, a new theme park where you'll step through extraordinary portals to 5 immersive worlds. Prepare for a cosmic voyage of discovery, an isle of fire-breathing excitement, a shadowy world of monsters and mystery, new wonders in the wizarding world, and a new way to play. Plus the splendor of a magnificent resort hotel overlooking the park. It's all new excitement at Universal Orlando Resort. A week's worth of vacation thrills with 4 amazing theme parks, a variety of spectacular themed hotels, and incredible dining and entertainment. It's all at Universal Orlando Resort, where you'll find new adventures every day. Explore the astonishing worlds of Universal Epic Universe at Universal Orlando Resort.
Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content. Because here's the thing, a good streamer can find other content.
Child Brandon been over there doing his thing, minding his GD business, staying out of trouble, trying to get the folks some positive stuff to talk about. Besides lying all the damn time. Child Brandon been over there doing his thing, minding his GD business, staying out of trouble, trying to get the folks some positive stuff to talk about. Besides lying all the damn time. Child Brandon been over there doing his thing, minding his GD business, staying out of trouble, trying to get the folks some positive stuff to talk about. Besides lying all the damn time.